I'll call CCR number 1392, In re Dana Burkdoll.
Good morning. I'm Todd Thompson. I am the appointed disciplinary counsel for the State Board of Examiners of Court Reporters. I would request 2 minutes for possible rebuttal. This disciplinary matter arises from 3 separate complaints in 3 separate cases from 3 different people. But they are consistent in that they all involve the repeated failure to timely produce transcripts and the repeated promises that were not met. The result was delayed trials, significant problems for the parties and the trial courts. For example, a 6-month delay in a deadline for filing dispositive motions, an 8-month delay before a trial could be held and had to be rescheduled. So the results were significant. The repeated requests and repeated broken promises, for example, in the Gibbons complaint, there were over a dozen requests and promises that were not met. The same was similar for McCrae and for the Attorney General's office complaint. Now, once the complaints were filed, the respondent has been very cooperative. She admitted the allegations. She stipulated to facts to expedite the hearing. There really was no dispute about any of the material facts. And the board recommended a 12-month probation with quarterly reports indicating essentially how she was doing on getting transcripts turned around. Some of the complainants thought that the quarterly reporting was not frequent enough. So we filed a brief and suggested that perhaps this court require monthly reports to a third party so that respondent could be monitored.
What's the third party bit of that? You don't like the recommendation that the reports go to the board?
The reports can go to the board. The problem is the board does not really have a permanent staff that is constantly ready. And I would point out that by volunteering, she has been doing monthly reports, but she's received no response, and sending them to the board, but she's received no response on that. So they've kind of gone into the ether. So we requested the monthly. She's been doing that voluntarily. The third party is an issue, but I'm obviously encouraged to have learned that she has voluntarily done the monthly reports. So that's really where we are. We haven't taken issue with the recommended discipline other than asking that it be more frequent and subject to monitoring.
Thought there was something about you're asking for some kind of an admonishment.
Well, I think she should be admonished for her delay, but I think the board's the probation is.
Did I understand it that was a request of yours that was in addition to the board's recommendation?
There is no admonishment in the board's recommendation, and I think there should be.
And I guess my question is just, isn't a 12-month period of probation in and of itself an admonishment? I just didn't understand what you were asking for, I guess.
I'm not sure it is entirely the same. And I am also conveying some of what the complainants expected or were hoping for from the board. And I think that it would be appropriate to advise not just this court reporter, but all court reporters that they need to be attentive to the timeliness of producing the transcripts because it causes problems.
You don't think a 12-month probation does that?
I don't think that's an admonishment. It is discipline.
Here, it's not just timeliness either. It was,
The broken
Reliance on-
promises.
right, reliance on the assurances that it's coming out. I've almost got it ready. That kind of thing. Because if it was only a delay, then somebody would have perhaps said, this needs to go to somebody else to be typed. Something like that.
I think that the repeated promises that were broken are a critical part of what needs to be disciplined in this manner. And I think an admonishment to that effect is appropriate.
You're not asking for any time that she's unable to.
I'm not.
You know whether the monthly reports that have been voluntarily submitted are sufficient in what you were looking for, or is it hard to tell because the board staffing issue?
It's hard for me to tell because they have not been sent to me and I have not reviewed them, but Mr. Biggs has advised me of them and just showed me one this morning. But I haven't had time to study it.
Why haven't they been sent to you?
I don't know.
Did you ask for them?
No. They are not part of the discipline at this point. That was just the recommendation of the board. They've been produced voluntarily. Any other questions? Thank you.
Morning, Jim Biggs on behalf of the respondent Dana Burkdoll. As you can tell, we don't dispute any of the facts in this case, and we don't allege that any of the information that's been provided by the board in this case is wrong. What we are saying is that my client knows that she made a mistake. My client knows that what she did was not right. She's not making excuses for it. In fact, what we were asking, because there aren't many court reporter disciplinary decisions out there, what we are wanting the court to do is consider some of the mitigating factors that have occurred, because in disciplinary actions, the court looks at aggravating and mitigating factors. And in this case, there were some mitigating factors that were brought out during the hearing in front of the board. One of those mitigating factors is the pandemic that hit. Understandably, it affected everybody, but it also affected my client's ability to staff, as well as what the Child Tax Credit Act that allowed for tax credit for people to stay home with their children. And that caused, in the testimony, you'll see it caused my client's staff to go from 12 to 14 people to 6 people. And that included scopists as well as proofreaders in that situation. Also, there was a death of her ex-husband. That's a personal issue with her, but it did affect her for a while, even though it was her ex-husband. They were close. The testimony in that discusses that also. And then finally, as the brief of the prosecutor, Mr. Thompson, stated, she cooperated throughout this process. When she got the complaints, she responded to them. She entered stipulated facts, didn't contest it. And the mitigating factors that I'm talking about, they're not excuses. They're just things that were occurring in her life that caused her delays. No excuse for telling the other attorneys that I'll have that to you next week. I'll have it to you in a month or 2 months later. If you look at the facts in this case, everything occurred within approximately an 8 to 9 month period. She's been a court reporter for 25 years. She hasn't had any discipline complaints in the past against her with regard to this. If you look at it, it's about when everything happened, and she testified that in July, she noticed her delays started and she knew she was in trouble in July because staff was reduced in July. Her booking she got way booked up and she was delayed. Again, does not excuse what she told the other attorneys and everything in there, but I think it's something that needs to be considered. We also discussed at the board hearing what protocol she has put into place to avoid this ever happening again. And she specifically set forth what protocol she now has in place to avoid this. Number one is I'm not taking as much of a workload. I've got people that are what we call trackers. I've got people that deal with emails. And so she's placed these protocols in place to allow this to not ever happen again. And so what we are requesting is, and as Mr. Thompson said, my client has been providing voluntarily since the recommendation came down, a monthly report to the board with no response, but that's all right. She wanted to show that I'm serious about complying with this and showing you exactly what the board requested of me back on April 10th of 2023, when the board said they wanted the date that the transcript or the deposition was scheduled, the date it was taken, the date it was ordered, and the date it was provided to the parties. And those documents do show it now. This isn't a form that was provided by the board because that was never given to my client. So she created her own that provides all that information that's been provided. So what we are asking is that the court adopt the recommendations of the board with regard to the quarterly reporting, even though she's been doing it monthly. And also, as far as the third party, I don't know who the third party would be. I mean, obviously, it should be the regulatory agency, the board of certified reporters, but they're not providing any response or communication or acceptance to what's happening. So with that regard, I don't even know if that's a possibility under these circumstances or where she would need to provide those other than where she is currently providing them. I don't have anything further if there's any questions. Thank
What
you.
do you recommend?
I'm willing to recommend that the board recommendations be approved by this court, be affirmed. The one thing that's a twist is possibly where does the third party? That was one of the recommendations from the board. How do we address the third party? We've been sending it to the board, whether or not that's sufficient, whether or not they're.
Help me understand. I thought you just said that the board recommended a third party.
Well,
I thought the board's recommendation was that the reports go to the board.
they were, I apologize.
Okay.
Mr. Thompson,
The-
third
yeah.
party, so.
The
Yeah, so how we deal with that third party is question, and I'm not sure. My recommendation would be it would continue to go to the board. My client retain documentation showing that she submitted it to the board. So if not, then she can show proof that she has provided that to the board. Additionally, I would ask that the court take into consideration, for lack of a better term, time served, since she's been providing these to the board per the recommendations since April of 2023, that go towards the 12 months in which she has what the board recommended.
You heard Mr. Thompson's recommendation of an admonishment for the probation, if you will, to be tied to. Tell me, given the circumstances here, why your client should not be admonished for what happened during that night.
I think taking into consideration everything that was going on in society, taking on what happened, her practice, as well as personal things occurring in her life, that those are mitigating factors, that they, as I stated earlier, they're not an excuse. However, and the fact she's never been disciplined in the past, she's fully cooperated, she's taking this seriously, and she's done everything that she could possibly do to try and rebuild what happened. earlier. I mean, she still does work for the Attorney General's office. I mean, I think this was a temporary, as you can tell by the time period lapse that occurred just by a storm that was building and it hit and it resulted in some actions by my client that don't represent her practice as a court reporter. However, it doesn't provide the excuses of what happened.
I understand that. I understand she regrets it very much, that she's sorry that those things happen, and she's been very cooperative. Were other court reporters complying with during the same period of time?
That I couldn't comment. I mean, I would assume so. I mean, she indicated in her testimony that she thought that they were complying with the reasonable standards. Questions? Thank you.
Thank you. Thank you to both of you for your arguments. We'll take this matter under advisement.